Hello everyone, my name is Hyungju Yoon and I'm a lawyer practicing in Korea. I've been thinking of opening my YouTube channel for quite a long time since I've had lots of foreign clients here in Korea, and I've got a bunch of questions from them. And also I was a guest of a local English channel and radio channel for 2.5 years, and I got lots of law questions from the foreign listeners. So I got to know that Korean law is quite complex to you. So from today, the very first day of the year, with all the accumulated scripts and experiences, I'm going to try. So I hope you like this video and you get what you need from my channel. To briefly introduce myself a bit, I studied public administration and economics in Korea. Then I started my first career in Singapore. And after working in Singapore for 2.5 years, I came back to Korea and went to a law school. After JD course, I passed the bar exam, and then I practiced it as an in-house lawyer at a private company, and then I worked for the Ministry of Justice of Korea for several years. Well, it's my 8th year as a lawyer in Korea, and now I'm in Gwangju City, located southern part of Korea. In here, I'm working with foreign clients from all around the globe, like US, Canada, France, China, Japan, Vietnam, Russia, Uzbekistan, Mongolia, Philippines, Malaysia, Singapore, and so on. And I can speak Japanese and French as well. So I am used to work and communicate with foreign clients who live overseas or outside of this town remotely. I can communicate and do my job. I also have co-workers who can speak Chinese, Mongolian, Russian, Vietnamese, and Bahasa Indonesia, Malaysia, and so on. So I think I have some advantages in legal issues that foreign expats or immigrants in Korea may go through. And me myself lived in Singapore as an expat. I understand your situation and feelings. So I think I'm the right one who can explain all this complex Korean legal system and the cultural backgrounds of such law to you in English. So today, I'm going to talk about Korean criminal legal procedures, which is the topic that I'm asked most frequently. Once any criminal offense is detected by the police, they start investigation. The investigation can be initiated by their internal investigation process or any reports or charges from outside, like the victims or a third party report to somebody else's criminal offenses, or the police officer can catch the offenders red-handed at the site, of course. Once the police acknowledges such criminal offenses, they start investigation. If the case is petty or minor one, they just bring the offender to the jigude or a police substation and doing investigation there and just release the offender there, finish the case there. If they judge it that the case is a serious one or the big one, important one, they bring the offender to the main police station and start investigation there. The offender can be detained from the investigation stage in Korea as well, like in other countries. As you know, detention is to ensure the suspect appears in a criminal trial and to prevent the destruction of evidence and to enforce the affirmed penalty. To detain the accused person, the prosecutor must apply for a warrant to the judge and show that warrant to the accused person. But there are some exceptions as well to the warrant requirement system. The first one is urgent arrest, which is 긴급 체포 in Korean. If there is considerable reason to believe that the accused person is guilty of a crime which is subject to capital punishment, life imprisonment, or imprisonment over 3 years or more, and there is a risk of flight, destruction of evidence, or in an urgent case, the prosecutor or the police officer may arrest the accused person without a warrant. In this case, only 48 hours of detention is permitted. If the prosecutor needs more time to investigate, the prosecutor has to apply the issuance of a detention warrant to the judge within 48 hours. So if the warrant has not been applied or has not been issued within that timeline, the accused person must be released immediately. The second exception is capture of flagrant offender, like caught red-handed at the crime site. 현행범 체포 in Korean. The offender who is in the act of committing a crime or has just finished the crime can be arrested by the police officer or actually by anybody who passes by or at the site. Like you, the normal civilian also can arrest without a warrant, but you have to immediately turn the offender over a prosecutor or the police officer. In this case as well, only 48 hours of detention is permitted. If the prosecutor needs more time to investigate, the prosecutor has to apply the issuance of the detention warrant to the judge within 48 hours. Plus, any person who is detained but later released by the police officer or the prosecutor shall not be arrested in connection with the same crime again unless other important evidence is found. But if the detention is made by the warrant, the timeline is different, much longer. When the police detains the suspect, the detention lasts maximum 10 days and no extension is allowed. But if the prosecutor actually received the suspects from the police officer and they start investigation, they are allowed spend 10 days for the investigation. But if there is any good reason to continue the investigation, then they can actually request the judge to grant the 10 days more for the investigation. So total 20 days can be allowed to the prosecutors. So all plus maximum 30 days for investigation, 10 for the police, 20 for the prosecute. And the period of the detention by the court is much longer. It allows 2 months basically for the first trial. And if they need more time, then they can actually extend 2 times more. And each time it can be 2 months. So total 4 months of the extension is allowed. So maximum 6 months in the first trial court. And in the appeal and the Supreme Court, if the defendant or the lawyer requested additional deliberation for the examination of the evidence or document submission, actually the arrest period may be extended for a third time. So basically they allow 2 months of detention and 6 months more for the second and the third stage of the court trial. So the appeal and the Supreme, they each can have the detention period of 8 months. Well, today we talked about the Korean criminal procedures and we dig more on the detention and the detention period. Next time, we will see more on the investigation and trial procedures. So this is it for my first footage. I hope hope it helps, and I wish you a happy new year, and thank you for watching this video. If you like this video, please subscribe and like. Thank you. Bye bye.